Welcome and thank you for joining Seyfarth's webinar, Labor and Employment Issues and Disruptions in the Transportation and Logistics Industries. This is part one of our micro webinar series focusing on topics of interest to these industries. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your screen. We will do our best to get to everyone's questions, and any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendee verification code will be read at the end. Please write this code down. It is required for CLE credit. Copies of the webinar recording and presentation materials will be shared with attendees following the program. At this time, I'd like to turn the program over to Andy Scroggins. Andy, you may begin.
Thank you, Kim. I'm Andy Scroggins, and I'm joined today with my partner, Ada Dolph. We're both in the Labor and Employment Department and based out of the Chicago office of Seyfarth Shaw. Let's go to the next slide if we can. This is our agenda for the day. We're going to give you a quick trip through 4 topics. We're going to start with Ada speaking about recent unionization efforts that we're seeing in this industry and across the country. That's going to be followed by a discussion of EEOC litigation and priorities at the moment and forecasted into 2023. We'll then speak to you about biometric privacy and in particular what's happening in Illinois with its BIPA statute. And we'll close with some developments in arbitration, again, that are impacting the transportation and logistics industry. And with that, I'll turn it over to Ada to kick us off on the substantive topics.
Thanks, Andy. Okay, so first topic, unionization efforts. I think it takes about 2 minutes to read a headline in the newspapers now to know that the unions have been making major strides in terms of their efforts to unionize and bring down barriers to unionization in 2022. I'm going to hit just a few high points that we want to make sure you're aware of. So next slide, please. And next slide. Okay, so there's a ruling that came out in October 2022, which changes negotiations in a significant way. So as you may be aware, upon the expiration of a collective bargaining agreement, the union dues would stop being collected when the contract expired. The ruling in Valley Hospital Medical Center is that the union dues are to be continued to be removed from employees' paychecks even after the contract expires. So this is significant in that it's typically been a point of leverage for employers that the union's monetary stream is cut off at the expiration of the contract, and then there's an incentive to continue negotiations and to reach a resolution. You could still address this by including agreement in your collective bargaining agreement that would address it if you have enough negotiating power. So you could put something, one line in that would say, we agreed that union dues will cease being collected upon the expiration of this contract. Something very simple like that, and certainly would be enforceable. But as of now, this is a significant change. If your collective bargaining agreement does not have some reference to dues collection, then you're going to be governed by this ruling. Next slide, please. The other significant development, and Andy's got a little bit more about this because it's been a focus of this administration, is the joint employer rules. So we have a proposed rule that's announced that basically takes us back to where we were under the Obama administration. And what's significant about this is it says that 2 or more employers are considered joint employers if they share or co-determine those matters governing employees' essential terms and conditions of employment. So the co-determine piece there is if you jointly decide anything, you're going to be considered a co-employer, essentially. The language of this that is even more problematic and merits a review of your contracts, for example, with your temporary agencies, is this concept in the 3rd bullet there where it says the NLRB will consider direct evidence of control and evidence of reserved and indirect control. So if you have control reserved to the employer in your contract with a temporary agency, but you never exercise it, even that is sufficient here to have you be treated as a co-employer. So this is worth taking another look at those agreements with this in mind and deciding affirmatively whether you're going to take on the co-employer title or whether you would like to minimize that in some fashion. Next slide. Okay, and here's a development that we've seen, not formalized yet, but we want to make you aware of it. The NLRB General Counsel is adamantly opposed to captive audience meetings. And what I mean by that is a meeting that the company requires employees to attend no more than 24 hours in advance of any vote. Previously, and under the current law, those are permitted. However, the NLRB General Counsel has come out with a position that she believes these meetings should never be required or held. So what we're seeing is situations where the captive meetings have been held that the General Counsel is seeking to negotiate into settlement terms that there will be a blanket prohibition on mandatory meetings regarding union activities. So while this isn't the law yet, it's certainly where the General Counsel is headed and something to keep in mind as you're dealing with union campaigns. Next slide. And then just a quick update. I'm sure everyone's seen the headlines about the rail strike, which appears to have been averted. And I say appears only because we certainly have an agreement that has been foisted on the unions. There were 12 unions covered by the rail a collective bargaining agreement that had been presented and negotiated at some level by the presidency. And I believe it was 4 out of the 12 unions voted against that agreement. Nonetheless, as you have seen, Congress acted and Biden signed, I think over the weekend, the collective bargaining agreement that will be imposed on the rail industry. There was an attempt at the last minute to add 7 days of paid sick leave to this bill, sort of amending the collective bargaining agreement, but that passed the House, but not the Senate. So they are still remaining at the 1 personal day, and then there's some preemption arguments with respect to the other paid sick leave time that are helpful in cases of dealing with state laws. The anticipation is that everyone will comply and that we have a lawful collective bargaining agreement. There has been some talk, however, of an unlawful strike of workers still walking out on the original deadline of December 9th. They would be subject to termination if that occurs, so it seems unlikely, but nonetheless, we're watching out for those sorts of things, and you may want to have a game plan in place for those types of responses if this impacts you. With that, I will turn it back over to Andy.
Thanks, Ada. We're going to talk now about the EEOC. If you could go to the next slide, please. So why are we talking about it? Well, first of all, there was not a lot of litigation activity by the EEOC in the last fiscal year. We identified only 5 lawsuits that they filed against companies in the transportation and logistics industries. But there were some additional suits that were filed against staffing companies who are placing people on assignment at companies in this industry. And we'll talk about what we think is coming up in the future. You know, kind of getting to Ada's point about changes in the joint employment relationship, it does dovetail with what the EEOC has been doing. Part of their strategic enforcement plan, which they call the SEP, is to look at complex employment relationships. And although that SEP is expiring and there'll be a new one in 2023, it's something that we think is going to be renewed, I guess, for lack of a better word, in the new SEP, and maybe even with some finer points put on it. And then finally, as I mentioned, we do expect an uptick in litigation next year for reasons that I'll talk about. Let's go to the next slide. So the EEOC's fiscal year comes to an end on September 30th of every year. And what we see is that the amount of complaints that they file spikes as they get closer to that deadline, as they're trying to sort of make the case for their continued funding by showing that they're active and enforcing the laws. In 2022, they were filing fewer cases than they had in the year before. And even September, which has the typical spike, you can see it shot up, but again, not as much as normal. And there was less activity in September this year than we would normally see. Let's go to the next slide. This is kind of a recap of where those suits were filed. And what this tells you is that there are certain district offices of the EEOC that are much more likely to file litigation against companies than others. You know, Birmingham, Alabama is just not aggressive about its litigation. Chicago, on the other hand, has historically been a heavy filer, and they actually lost their first place slot last year, but they bounced back. So you can see if your operations line up with some of these more active districts, you need to be a little bit more aware of the possibility of dealing with an EEOC initiated complaint. And what it also speaks to is that if you just get a charge, kind of be a little more on guard if it's filed within the Chicago district, or if it's filed in Miami or Charlotte, which is getting much more active. Dallas, Phoenix are actually a little down from where they historically have been, but you know, treat those charges with a little more caution, because you're more likely to face an aggressive office if they feel like they've sniffed something that's wrong. Let's go to the next slide. This breaks down the kinds of lawsuits that the EEOC filed last year. Title VII is always the biggest, represents the biggest number of lawsuits, and that was true again here. But we've also seen that age discrimination claims are creeping up, and Equal Pay Act claims are creeping up. That Equal Pay Act thing is something to keep your eye on, particularly as we're seeing more action in state and local governments about pay transparency. I think that's a trend that we're only going to see grow more. And then we have a breakdown on the other side, since Title VII covers so many different bases of discrimination. And you can see that sex discrimination continues to be the largest category of Title VII claims. But interestingly, hostile work environment claims have gone down. So, you know, pretty significantly by about a third from last year. And those cases where we did see them were most often brought on the West Coast instead of being distributed around the country. So, you know, maybe that means we're seeing numbers come back down to historical norms after we've had a long run of Me Too attention that seems to have driven the EEOC's focus in this area. But we may learn more about their intentions there when we see the new SEP in 2023. Let's go to the next slide, please. So something I think is not commonly known is that the leadership of the EEOC doesn't change when a new administration comes in. Commissioners are appointed to 2-year terms, and then there are rules about what they can do if there's not a replacement who's ready to step into the seat when their term expires. They can stay on. So as a result, you know, we're looking at only 2 Democratic appointees on the commission right now. Chair Burrows, who you see pictured there, has been on the EEOC before. And you can see the periods of time that we have for the others. We actually just had a resignation by former chair and recent commissioner Janet Dillon, who resigned at the end of November. There's no replacement in the queue for her, but I think we can expect that to happen now with what we've learned about control of the Senate going into the next congressional term. And then also happening last week is that the Senate was finally able to advance the Biden administration's nominee to be general counsel for the EEOC. So you can see that this shift is coming. Let's go to the next slide, please. So here's why we expect to see many more filings in 2023. First, with the resignation of Janet Dillon, the 3-2 majority of Republican appointees has now ended, so they're deadlocked at 2-2. That's significant because for the EEOC to bring its largest cases, they need to get majority approval by vote of the commissioners. So with the Republican appointees having a majority, they've actually said no to a number of lawsuits. We have reports of what they've voted down, but they're kind of vague. They don't tell us who the employers are. Just they give us some general descriptions about the allegations that would have been part of the suit had it gone forward. What we've learned is because the general counsel, who's a Democratic appointee, isn't happy with that. They want to be able to bring the suits that they've raised to the commission for vote. They've been taking those lawsuits that are voted down and sort of parking them And instead of dismissing them, they're kind of holding them. And we know that there's a pile of cases that that she's sitting on, probably that the regional offices are sitting on, and we think that they're biding their time where they think they have a significant case and waiting until there's control at the commission level that will allow them to bring the cases that they've wanted to bring. Another interesting wrinkle to that is, I mentioned the voting process that's in place now. That was actually something that was put in place when Janet Dillon was the chair. And it could be possible that with a new majority of commissioners, they just strike down that rule altogether and delegate that authority back out to the regional attorneys to decide what litigation they want to bring. And then, we might see activity all around the country, and I expect we'll see a spike that happens with that transition in leadership rather than waiting until the end of the fiscal year, because some of those cases have been aging and they won't want to sit on them too long. I mentioned before that the SEP is expiring. The EEOC commissioners have been doing listening sessions where they bring people together to talk about certain topics. I've listed them here, and you can see, like when we talked before about looking at complex employment relationships, that kind of dovetails with their thinking about vulnerable workers, temporary workers. So I still think that's going to be a priority in some way. We'll just have to see how they articulate it. Another thing to put on your radar, though, is that the EEOC, a couple of the commissioners are very interested in artificial intelligence and algorithms as they're used in the employment context. And even though those sound like fancy words, they have a relatively rudimentary understanding of what those concepts mean. And as a result, they often think about processes that are automated that we wouldn't really characterize as artificial intelligence or algorithms, but they kind of put that in that bucket. And they're really scrutinizing any parts of the hiring process or performance management process that are handled in some way within a computer. So if you're using those kinds of processes, make sure that you understand how it works and that you're doing some check to make sure that it's working in a way that's fair, because the EEOC might scrutinize it if they learn about it. And we've written plenty of things on that topic if you want to reach out to learn more. And I think that is the end of our EEOC section. Yes, so Ada, back to you.
Thank you, Andy. Okay, so biometric privacy has certainly not waned in importance, particularly in Illinois or anyone who operates for any company that operates in Illinois. Next slide, please. We had a major development just this last October where things got very real. A jury deliberated for just 1 hour before ruling against the employer for violating the Illinois BIPA Act, as we call it, as to people performing work at its rail yards. The judgment that was entered was $228 million in damages. And there's a related case that could impact that judgment as well. So we'll talk about why they got to this $228 million in damages, but let's start at the beginning. Next slide, please. Okay, so BIPA class actions are a relatively recent phenomenon, even though the statute has been around since 2008. So you can see here on the slide the extensive and massive increase in BIPA class actions. Also, there was an Illinois Supreme Court ruling that held that there's a very low level of pleading required to sustain your case in state court. And that was in the Rosenbach versus Great America case. So you can see that before and after that case, it impacted it and made it easier for these cases to stay in court rather than be dismissed. So we're seeing more of those filings. And we do expect, particularly with this recent jury award, for this to continue. Next slide, please. Okay, as I mentioned, the Illinois Biometric Information Privacy Act was enacted in 2008. It was responding to a company's misuse of consumer information. That said, the statute is written very broadly and clearly applies to employers. What's interesting about the BNSF jury award is that in that case, that employer was not directly collecting the information. It had a third-party service provider who was doing that. Nonetheless, under the statute, the jury could hold the employer liable for the entire amount of judgment. So as most of you know, BIPA broadly regulates collection, use, safeguarding, handling, storage, retention, and destruction of biometric information. That is still being litigated, as is almost every part of the statute. What I would suggest is if you at any point in the employee relationship are collecting fingerprints or using facial recognition software, retinal scans, voice prints, etc., that you take a look at the statute, make sure you're in compliance. What's interesting is Illinois is the only one that has a private right of action for these cases, which is why we've seen the proliferation of them, including filed in other venues. You can see there that Facebook had settled one for a massive $650 million. That was a case pending in the Northern District of California. Google also had a $100 million settlement under BIPA. So the settlements have been driving the filing of these cases, and now we expect this judgment to do the same. What I would mention too is that Washington State and Texas also have a similar statute on the books, but there's no private right of action. It can only be enforced by the Attorney General of the state. What we've seen recently, so these statutes have been dormant for a long time, is that in Texas, for example, the AG is pursuing a complaint under the statute. So we're seeing a lot more focus and activity on this area of law. Next slide, please. So as I mentioned, this statute's relatively new. So there's all kinds of terms and definitions in the statute that are just not defined. And some of the main debate points have been slowly working their ways through the courts. So I'll mention here the territorial scope of these cases. There are judges that have found outside of Illinois, so that is in the Western District of Washington, that the employer at issue did not have a significant enough connection to Illinois, focusing on where the violation actually occurred. This argument has been one argument that has had some success here, but very limited in most instances. We do expect an Illinois court to pick this up and potentially rule differently. The other things that are being litigated are what is the penalty? When is it accrued? Is it accrued, for example, if you have fingerprint scan timekeeping, is a violation happening every single time that scan occurs? Or is it happening per individual? And then how many years back do you go? And some of those have been working their way through the appellate courts as well. Next slide, please. So a couple of additional BIPA decisions that we expect soon, and we're certainly keeping an eye on, is the first one here, Cawthron versus White Castle. This is an appeal before the Illinois Supreme Court, and it is going to what I was just talking about. How do you count the violations for the purposes of damages? Obviously, with this over $200 million award for BNSF, that was a significant number of employees and a significant number of penalties being assessed. Then we also are waiting on the Walton versus Roosevelt University case, again, before the Illinois Supreme Court, addressing whether union member claims are preempted by the Labor Management Relations Act. So the Seventh Circuit has already held yes, consistent with its initial finding rather, that the Railway Labor Act also preempts BIPA claims. But now we're waiting to hear what the Illinois Supreme Court says about it. And it certainly can say and has said things differently than federal court. Next slide, please. So considerations moving forward, if you're using anything that even suggests it's using or collecting biometric information, it's a good idea to check in with your lawyer, understand the requirements, and potentially get in compliance now, even if you have not been in compliance, even if that is just to cut off the accrual of any new claims. We're seeing, though, that this success in this area is causing plaintiffs' counsel across the country to take a look at the state privacy laws that exist and use the BIPA decisions to show that there's been some violation of privacy, that a court views it as a violation and that they should recover under various state laws. And then, as I mentioned, we're seeing activity from the Texas Attorney General as well. The last thing I would say is New York proposed a Information Privacy Act was nearly identical to the Illinois one. So we're also watching the legislatures. It did not make it through this time, but it's certainly a trend for states to be focusing on this area. Back to you, Andy.
Great, thanks, Ada. So we're going to touch briefly on arbitration here and close out our presentation today. Can we go to the next slide, please? So the reason why we're talking about it with you today is to give you a sense of the landscape. What we've seen in the recent past is that Congress has been acting to make arbitration harder to use in the employment context, while the Supreme Court continues most of the time to say that arbitration is just fine. So the takeaway, the main thing is I still would recommend that most employers have an arbitration agreement as a way to mitigate their risk of class and collective action claims, especially in the wage and hour context, and we'd be happy to help you do that. Let's go to the next slide. So I mentioned Congress had been narrowing the availability of arbitration. We saw a law passed in March, which restricted the use of arbitration in the context of sexual assault and sexual harassment claims. It requires some minimal changes to existing arbitration agreements in some cases, but most of the time the prior agreements can still be enforced, except that they can't be used if the claim is one for sexual assault and sexual harassment. A more sweeping change would be the Forced Arbitration and Justice Repeal Act. It sort of gives away its intentions there. The FAIR Act would say that you can't ban mandatory arbitration, that you cannot use mandatory arbitration or class and collective action waivers in an employment context pre-dispute. So this has actually been passed by the House earlier this year. It has not gone out of committee in the Senate. It's unclear whether there would be enough momentum to actually pass this into law before this term of Congress ends. They don't have much time to act, and I haven't heard any discussion about it. Also, with the change in control of the House, maybe this is an act that's going to die on the vine, but it has been introduced for multiple sessions of Congress now, and it does sometimes get bipartisan support. There are some Republicans who don't really like arbitration in the employment or consumer context either. So it is something to keep your eyes on because some acts of Congress would really change the way that we use arbitration agreements in the employment context. Let's go to the next slide, please. There were 3 decisions by the Supreme Court at the end of their last term that touched on arbitration. One was when an employer can be found to have waived their right to compel arbitration. So if they wait for a long time, the Supreme Court basically made waiver a harder argument for a claimant to make. So it's a favorable ruling for employers. In the Saxon decision, they extended an exemption to the Federal Arbitration Act. What they concluded was that certain people were really closely tied into interstate commerce, even if they weren't personally crossing state lines. And in this case, they were looking in particular at people who loaded cargo on and off of planes, and concluded that those people were transportation workers engaged in interstate commerce and could not be compelled to arbitrate their claims. It's really fact specific. It's hard to really draw out much about other employment situations. What we've seen is that after this decision is that appellate courts are mostly finding that they're not extending the exemption. So for example, we've seen cases with carriers who are making deliveries for that last mile, and they're not extending the exemption to them. Let's go to the next slide. And the final one is Viking River Cruises. It is a very complex opinion that gives employers a little glimmer of hope if they're faced with PAGA claims. If the individual who brought that claim is subject to arbitration, then they might lose their right to bring representative claims on behalf of others. We expect that that's probably not going to last very long. We think that the California legislature is just going to amend their rules so that this won't apply anymore. And let's go to the next slide. Okay, so bottom line on arbitration, we still think for now, you want to have an arbitration agreement in place with a class and collective action waiver. It's going to be enforceable most of the time with those exceptions we talked about earlier. And you also want to make sure that that arbitration agreement extends as far as it can, not just your own employees, but temporary workers or other people who might be on your work site if you can do that. And, you know, belts and suspenders, see if you can have some way that people who are providing you with contingent workers get arbitration agreements with their people that also can be enforced if you decide to, if they decide to bring a claim against you. So with that, I believe that we have, well, we've received some questions in the chat and we can respond to those after the fact. And let's get to the last slide, which I know is important to people, which is that CLE code.
The CLE code is
sorry.
SS, as in Seyfarth Shaw, 8978.
Great. Well, thank you everyone for joining us today. I'm glad we were able to land the plane right at 12:30. And please don't hesitate to reach out to Ada or to me if you have any questions about the content that we covered today. Actually, do we have one more slide in there? Yes, we do. So we do have another webinar that's coming up. It's listed here on another topic relevant to the transportation and logistics industries, and we hope that you'll join us then.